Great. Welcome back to Senate Education, Wednesday, January 18th, 2:47. We are jumping in on Acts 60 and 68, and I've asked Beth St. James to give us an overview of the legislation, how it started, kind of a historical perspective, and some of the impacts that we've seen from that. So with that, I'll just pass the time to you and you can get started.
Great, thank you. Beth St. James, Office of Legislative Counsel. As Chair Campion said, this presentation is meant to be very foundational and basic. You will see that there are dates in here from the 90s and the early 2000s.
Do we have a copy of that? Do you have a presentation?
I do.
Oh, you do, that's right. Did you already pass it out?
It's in the paper clip card.
Great, thank you. Okay.
This is meant to be foundational and relatively simple to orient you. My understanding is you will eventually have someone from JFO coming in and doing school education financing 101. Is that accurate?
We did some education financing 101 with Brad James yesterday.
Okay.
Yeah.
Well, then hopefully this will help. And if you do have anyone from JFO come in, this will hopefully be, again, foundational.
Great.
If you have questions, I am not.
I just want to make sure everybody sees. It is in the stapled packet if you need it.
It should only be 6 pages.
Great. Okay.
Very short.
Please go ahead.
This is presentation is really meant to just highlight what the state was doing before a seminal case called Brigham v. State, and then the kind of fallout from Brigham and the legislative action that came from it. I'm not prepared today to discuss education funding as it exists today. Okay, all on the same page? Okay, very scary subject. So you want to turn to title 2 or slide 2. So the case we're going to be talking about today is Brigham v. State. It's referred to as Brigham, and that happened in 1997. So this slide 2 is what was in effect before Brigham. Okay, and the state funded its education through what was referred to as the foundation plan. So the state set a foundation property tax rate annually, which was meant to be a reasonable rate of local property taxation that was supposed to raise enough money to cover the foundation amount or cost, which was the minimum needed to provide a minimum quality of education, and that concept was set by the state. And just making sure.
Yeah, let's make sure it is.
And we're on slide 2.
Yeah, slide 2.
Okay. So the state set a property tax rate purpose, and it was annual. And the purpose of that property tax rate was to raise enough money to provide a minimum quality of education, and that concept was defined by the state. If based on the grand list of the school district or town, the municipality that we're talking about, if based on that grand list and the foundational property tax rate, if a school district was not able to raise enough, the state provided a grant to get them to that minimum, the foundation amount, the foundation cost, what the state decided would be needed to provide a minimum quality of education. I'm seeing some confusion. Is everyone? This is.
So why wouldn't they raise their own revenue sufficient to maintain their own schools?
Are you talking about the towns?
Yes.
Let's get into the example. Okay. So remember, this is foundational, right? This is the base floor. Okay. So an example, we've got an example town, and the foundation amount that the state says you need to provide a minimum education is $5,000 per pupil. Okay. The base tax rate that the state has set is 1%, and the grand list in this town is $400,000. So they don't hit that
Everybody
5,000.
understand the grand list, I think, everybody.
Yes, the property in your town, that's the taxable property in your town. And that, what the property that is taxed will change a little bit as a follow-up to this, but for this conversation for that foundation plan, the grant list. So they can't raise based on the minimum tax rate, right? And the property they have to tax, they can only raise $4,000. So the state comes in and says, okay, we're gonna give you $1,000 to bump you up to that, to get you to that 5,000, which is the minimum necessary to educate people. All on the same page? No?
For the slow student in the room.
No, this is good. No,
So,
I'm glad you're asking questions.
so what prevents the town from increasing the base tax rate, or is that determined outside the town?
Slide 3. Okay, so this is, remember, this is what used to happen, okay? And so this is just a very, on slide 2, this is not about choice. This is just setting the foundation for what is the foundation plan. That's literally what it's called. It's providing a minimum level of education for students. So on slide 3, now we're looking at equity here, okay? So you've got 2 towns, one with lots of property wealth and one with little property wealth. Both towns want to spend $10,000 per pupil, okay? They're making a choice that for their students.
So the state isn't saying you should, the state isn't saying this is what's gonna educate a kid at 10, this is what they're deciding.
The state is saying the base foundation to provide the minimum necessary education for students in the state of Vermont is $5,000 per student. These 2 towns are making a choice. They're saying, well, we want to invest in our education. We want to spend $10,000 per pupil. How do they get that money? So we've got a property poor town with a grand list of 400,000 and a property rich town with a grand list of $1 million, okay? And we've got that 1% tax rate that the state is saying. We're looking at everyone to get everyone kind of on the same page with that minimum amount. We're going to say the tax rate is 1% for the state. So the property poor town can still only raise $4,000 on their grant list. The state's going to kick in $1,000 as the foundation grant to get them up to that minimum necessary. And so then they're only at 5,000 at that 1% tax rate. If you look at the property rich town at that 1% tax rate, they can raise that $10,000 without having to raise their taxes or receiving money from the state from that foundation grant. The property poor town could choose to raise its tax rate to make up that difference to get to that $10,000 per pupil.
That's what's in the green.
That's what's in the green, yes. But you've got 2 towns with different resources in their grand lists and the property that they have to tax in that town, making the same decision to spend money on their education. And that affects their community differently. It affects their tax rates very differently. And it may affect the choices that they're making on education spending, right? Do they want to raise their tax rate to go up to that $10,000? Or do they want to keep their tax rate low and hover around that foundation, the foundation formula for the minimum necessary to provide education? All on the same page? Okay. So that was the foundation plan. That was what was in place prior to 1997. Then we go to slide 4. We're back with our friends, the Vermont Constitution. The education clause. You should all be expert scholars on this by now. The Vermont Constitution says that a competent number of schools ought to be maintained in each town unless the General Assembly permits other provisions for convenient instruction of youth.
That's it.
That's it.
That is.
That's it. I will note as the Brigham Court notes, it's not on the slide, but I'll just note this. Education is the only government service that is in the Vermont Constitution. So there was no provision for
Roads, healthcare.
providing
Nothing.
for the vulnerable populations. Education is the only government service provided for in the Constitution. Then there's also the Common Benefits Clause, which I think we touched on a little bit when we talked about Carson v. Macon. And that says the government is or ought to be instituted for the common benefit, protection, and security of the people, nation, or community, and not for the particular emolument or advantage of any single person, family, or set of persons who are a part only of that community, right? So government is for all. So
Government is for all. not-
Government is for
Yeah, whatever, okay.
right? We've got, remember our foundation plan, right? Where we talked, where there was the property rich town who could keep that 1% tax rate and raise $10,000 per people. But we have a property poor town could only raise 4,000 on its own. Well, that concerns some people. And they filed suit. There were actually 3 different classes of plaintiffs in this case. Just for your, I know there were some questions last time I was here about could a tax payer sue. And so I just wanted to highlight for your interest, there were 3 different classes of plaintiffs here. There were students who alleged that the state's method of financing public education deprived them of their right under the Vermont Constitution of the same educational opportunities who students lived in wealthier school districts. So these students lived in a town with not as much property to tax. And they said, hey, my neighbors in the town next to me with a whole bunch of property to tax,
Yeah.
they have different educational opportunities than me, that's not fair. There were property owners from property poor districts who claimed that the current school financing system compelled them to contribute more than folks in a town that just happened to have a lot of property. And then there were 2 school districts who had kind of the same argument that they were claiming that they didn't have the sufficient ability to raise money and provide their students with educational opportunities that richer towns could. So those 3 groups of plaintiffs were all kind of bundled up together, just highlighting that to show you the different classes of people who were concerned about the education financing. For reasons that we will not go into today, the court really only focused on the students' complaints. And so you can kind of ignore the property owners in the school districts.
And the students basically said, again, town next to us,
This isn't
very different educational opportunities than
Yes.
what we're getting right here.
yes, equity, it's about equity.
Yeah.
So ultimately, the court held that, so the plaintiffs are saying that the foundation plan violated the Vermont Constitution by creating inequities between property-rich towns and property-poor towns. And ultimately, the Supreme Court held that the education financing system in place at the time, so the foundation plan that we just went over with those graphs, and this is a direct quote, with its substantial dependence on local property taxes and resultant wide disparities in revenues available to local school districts, deprived children of an equal educational opportunity in violation of both the Education Clause and the Common Benefits Clause of the Vermont Constitution. And in doing this analysis, the court really focused on the history of the Vermont Constitution and the fact that education was the only government service provided for in the education, and what that means to being integral to Vermont and the functioning of the state and the government's responsibility for providing education. So the state was arguing, yeah, we're going to concede that this isn't really fair, but this is a local issue. This isn't a state issue. So this is not the students suing their school districts. This is the students suing the state, right? So the state was saying, yeah, it's not really equal here, but this is a local issue. And that means that, you know, we should let it be a local issue. And the Supreme Court said, no, providing for education in the state of Vermont, enshrined in the Constitution. It's the only government service provided for in the Constitution. Is actually a state responsibility, not local. Funding of it doesn't take away from the fact that local decisions can be made, but the requirement that education is provided equally, right, under the Common Benefits Clause, substantially, the court says substantially equally.
Competent schools, competent education.
Yes, is that, let's see. Competent number of schools.
Competent members.
Yep. Enough to support the population. So the court said, no, state, this is your responsibility. So to fulfill its constitutional obligation, the state must ensure substantial equality of educational opportunity throughout Vermont. Now, the Constitution does not say how the state should do that, right? The Constitution says state, you have to provide for it, the education of Vermonters, but it doesn't say how that education system should be funded. That, the court emphasized, is the legislature's purview. So the Vermont Constitution is silent on how this obligation, the educational obligation, must be funded. And they said, although the legislature should act under the Vermont Constitution to make educational opportunity available on substantially equal terms, the court was realistic in recognizing that they were never going to create a system, or the legislature was never going to create a system that was perfectly equal for every student, right? There's variations, there's going to be variations. So the requirement is substantially equal. So the specific means of discharging that duty is up to the legislature. So the Constitution does not require the education system to be funded on property taxes, does not require a foundation plan, it doesn't require pupil weighting. It leaves that up to the legislature to decide, but the legislature has to make, in whatever system they come up with, has to provide for substantially equal educational opportunities for Vermonters. Any questions about Brigham? Okay, this is, and I should say this is a case that was decided by the Vermont Supreme Court in 1997. It's still good law. You will hear I don't know if Brad talked about Brigham at all or went into touched on Brigham, but when you're talking education finance, if you're talking any sort of history, there's always a reference to Brigham. So this is the case that we're referring to.
Does anybody have any questions at this point before we go?
Okay. So post Brigham, last slide. Legislature had some work to do. And the first thing they did was in 1997, they passed Act 60, which I know you have all heard because you've asked me about it. So Act 60 was the legislature's initial response to the Brigham decision. It did not change the way education spending is determined. Education spending is still a local decision under Act 60. But it moved funding of education from local funding to state funding and created the Ed Fund, which funds all of the school districts. It created a uniform tax rate across the state that supported a minimum block grant. And any spending above the block grant resulted in a higher tax rate for that town. And so I have a little example here. And anything raised above any revenues raised went into a state level share pool to be redistributed based on spending. So if you have town A, let's say they have $1,500 of property value per pupil, and town B has $500 of property value per pupil, but they both want to spend $1,000 in per pupil spending above the state block grant. Both towns have the same tax rate because they're spending, they want to spend the same amount of money. So the tax rate is correlated to spending now. Town A is going to generate $1,500 per pupil, but they only needed to raise $1,000 more than that block grant. So they've got a little slush there. They've got $500 in excess. That's going to go into the education fund because town B can only generate an extra $500 per pupil. So they're $500 per pupil short of what they want to spend on their kiddos. And that money is going to come from the education fund. And that's funded through the excess. There's other funds in there that we're not going to get into for this presentation. But it's partially funded by that extra $500 from town A. So they made a choice to spend the same amount on their students, which means they had the same tax rate. That tax rate is applied to their grand lists, property that they have there. And if they needed that money, the money would, help their per pupil spending. And if they didn't need that money because it was in excess, it would go to the education fund to help out all of the towns that couldn't raise money on their own grant lists. So it's tying, Act 60 is really tying the property tax to education spending.
Quick question, I guess it's just semantics, but is the block grant pretty much the same as the foundation amount prior to the Brigham decision?
Yeah, for the purposes of this conversation, let's say yes. It was set annually in statute, and it was the amount of money that the state was going to kick in per pupil for education across the state.
Okay.
I don't know if the math was the same, but for this conversation.
Got it. Thank you.
And it took several years for this to actually be implemented. I think the full implementation goal was 2001. And then in 2003, Act 68 moved us a lot closer to what you see today. And the big takeaways for Act 68 are it split the grand list into homestead and non-homestead property. And there's different tax rates for those now. That was not the case prior to Act 68. So it created a homestead property tax rate that varied again based on education spending. And then it created a non-residential tax rate that was uniform across the state, which means it didn't change based on local education spending decisions. And it also made the town's education property tax rate proportional to the spending approved by its residents, not on spending above the block grant approved by all towns. So it was really tied to the community itself, not a statewide decision.
So just to confirm, Act 68 basically got rid of this system developed by Act 60?
No, it amended the system.
Okay.
So the big difference in Act 68 was the splitting of the homestead and the non-homestead property tax rates. So under Act 60, every property in the community is taxed at the same rate for educational purposes.
Yep.
Residential homes and vacation homes, or just non-residential homes in general.
And then Act 68 created.
Split them.
Got it.
So now, under current state law and under Act 68, the homestead property tax rate is going to vary depending on education spending. And what that looks like today, I assume Brad either went over or you're going to have JFO come in and do that. But it varies based on education spending. But the non-residential tax rate is not affected by educational spending. It's the same no matter where you are. And those are the big takeaways for Act 60 and 68 and Brigham to kind of orient you to where we are today. A lot has happened since then.
If you can take the non-residential tax rate issue to the next step, was it intended to be lower, higher? I'm not a vacation homeowner.
So tax questions, I would really encourage you to reach out to the attorney who's
Just the philosophy of it in in 2003.
So I don't know about the intent behind the splitting of that, but again, for tax questions, that is not my area of expertise. So the fallout from that and what that meant for non-residential homeowners would really be a question directed for Abby Shepherd.
Okay.
But for purposes of our conversation, Act 68 was the thing, the piece of legislation that made that split. Tax and education funding go hand in hand. And my ability to speak to it really stops if it's not in Title 16. And all of the tax concepts are in Title 32, and that is Abby Shepherd's area of expertise. And I did reach out to her. She knows I was presenting on this, and she knows she may get some questions
Great.
on this.
Senator Williams, go ahead.
Cool, thank you.
Could somebody today say, could a kid or a family say, listen, my child went through school district B and he or she came out of school district B not being able to, read at grade level, do math at grade, that kind of thing, and say, okay, we've got a problem. Or my kid, maybe a better way to do it is, my kid just doesn't have the same opportunities in terms of classes that, another school has in terms of offerings. And we're going to try to set this record straight. Could that kind of lawsuit happen today?
Yes, my standard question anytime anyone asks me if any type of lawsuit could happen is always yes, because anyone can sue anyone for anything,
Yeah.
at any time, any place. Doesn't mean they're going to be successful.
Yeah.
So there have been lawsuits. There is a case that's in the Vermont Supreme Court now that we're waiting on a decision on any day that does make an argument under the Common Benefits Clause that children in school districts that have a brick and mortar school are not getting the same benefit under the Common Benefits Clause of a student who lives in a town school district that doesn't have a brick and mortar school, because the student in the town district, the tuitioning district, gets to go anywhere they want.
Yeah.
They get to hand pick those courses.
Yeah.
They get to hand pick those extracurricular activities. And the students who are growing up in a town with a school don't. They are, unless their parents want to pay for them to go somewhere else, they have the opportunities available in their school district. So yeah.
It's good that you're bringing this up because I've followed this case a little bit. So tell us a little bit more in terms of, is it the family looking to sort of expand their opportunities, or are they concerned that different areas have opportunities that they
So
might not?
there's two types of challenges that can be brought to a law.
Yeah.
I think maybe I'm missing what you're saying. To go back to answer your original question, yes, someone could say that because they have different opportunities in their school district than someone else, the educational opportunities are unequal. It would
Right.
really depend on every case, the facts of the case, right?
Yeah.
But what is their argument? Are they saying that it's because of educational funding?
Mm-hmm.
Is it because it's the choices that the school board is making?
Right.
Is it, so it really
Is it the
depends.
state that's not requiring certain?
Exactly,
things to be
right,
offered?
right. So, but yes, there could be, and I think there have been, I don't want to speak out of turn. I think there have been various arguments that have bubbled up here and there of students arguing, families arguing, students arguing that their school didn't provide enough extracurriculars, or it wasn't fair that their school didn't have the same extracurricular opportunities as another school district. And none of those cases have really had traction yet. But the case that I was referring to that's in the Vermont Supreme Court now, there's kind of two different challenges that someone can make in a law. There's as applied and there's facial. So as applied means the law has been applied to me, and that application, there's something wrong with it. It's unconstitutional. They didn't actually follow the law as the law was applied to me specifically. That, something illegal happens there. I deserve a remedy here. I deserve a fix. And then there's a facial challenge, which means that the law in and of itself is not okay. And that would invalidate it potentially for everyone. The case that we're talking about in front of the Vermont Supreme Court was a facial challenge. So they're arguing in general for all of Vermonters. It's not fair that some students get the option to tuition and some don't, because the right to education is foundational in Vermont's Constitution, and it's a common benefit. So they're arguing that there's an equity issue there.
So could the court come back and say, okay, we're going to give choice to the state? Or could the court come back and say the choice that exists is going to disappear, or of something else?
The court is not going to, so the court could come back and say this scheme is unconstitutional, like they did in Brigham.
Right.
But it's up to the legislature
Find a solution.
to find a solution or not find a solution, and then face another legal challenge.
Yeah.
And another legal challenge. But yes, the court is very unlikely to come back with a roadmap for exactly what the legislature should do. That's the legislature's purview to make the laws. The court interprets them. But that, I'm checking every day, every Friday when opinions are issued, because that's an interesting one to follow. But that is not related to, it's not directly on point to Brigham, although they relied on Brigham a lot in their arguments. It is an equity argument under the educational clause and the common benefits clause. It's just not directly specific to educational funding.
Interesting. Any questions? Yeah, please.
Going backwards to the Vermont Constitution, just curious, really no language on what ages that the school requirement should be applied to. How did they ever determine that? And are there challenges now in respect to earlier or later education?
You determine that, the legislature. So in Vermont, attendance in a school is compulsory between the ages of 6 and 16. In Vermont, kindergarten entrance age, you have to be 5 by August 31st of the school year. Between August 31st and December 31st of the school year, but a school district can make the entrance age anywhere in there. So there are some school districts who say you have to be 5 by August 31st, and there are some school districts who say you have to be 5 by a different date. I don't know off the top of my head if anyone actually goes all the way out to December 31st, which means that kiddos could be starting kindergarten at age 4 if they don't have to turn 5 until late September, October, November. And then on the other end, it's compulsory only to age of 16.
And I should mention, if people are interested, former Senator Nifka put in a bill last year, the year before, that said enough of the 16 thing, it should really be 18. And we did get a lot of pushback. I mean, we took a little testimony, but we heard from people it wasn't a good idea for a variety of different reasons, but I'm happy to explore that again. Yeah.
I was just going to add to the kindergarten discussion. This was something we talked about in the VSBA over the summer, or maybe it was fall, but just because we were asked if we thought we needed legislation around a more specific date for kindergarten entry, or if we wanted it to change, or if the VSBA wanted to weigh in on it. I think in the end, we just decided to sort of leave it as is, which is there is some flexibility there. But some states are really strict with like January 1st or, you know.
Yeah, no, that's really not where I was going. I was
Right.
really kind of more interested in the early education, early childhood education, and then, post high school. If there was ever an attempt or whatever, modify that.
What was the argument about 16?
Remember why we didn't move it up to 18?
Yeah.
do you remember any of that conversation?
I don't know that I've been a part of any.
Yeah,
legislative
I
conversations
remember
like that.
when it was, I think really, what are you gonna do if a kid wants to leave, kind of thing, and what kind
Yeah,
of
no,
kid's
some
sitting
kids are
there,
ready to be
some,
done,
you know,
yeah.
ready to be done, but, happy to pull that conversation
No,
back up
sure.
if people are interested,
Mhm.
yeah.
There's also
Yeah.
kids who finish school early and go to college early. I don't know if
There's that
happens
too, yeah,
super
yeah.
often, but
Yeah.
Mhm.
And there are provisions for like if a student matriculates early, they're not truant if they have fulfilled certain requirements. And then pre-K, early childhood education is different. It's provided for differently than the rest of the education system in Vermont.
You wanna ask something to that, or-
No, I was just curious where that was going. Constitutionally, pre-K, I mean, I'm just curious of the boundaries.
I don't have an answer for that. I don't know constitutionally. The Constitution doesn't spell out what ages the state is responsible for providing.
That's fine.
Nobody's ever asked it before. So,
But it's back to that.
There's a cool thing called early college too, which we haven't talked about.
Right, we've got some time on flexible pathways and
That's
really,
neat.
yeah. Okay, this is really helpful.
Good.
Yeah, just give us a,
You can get a lot more detail on this. Act
Sure.
68 specifically was a huge bill and it did a
Yeah.
lot of things.
yeah,
But this was just meant to just be very basic foundational and really to orient you to Brigham and the constitutional requirement for the state to provide education for its students in a substantially equal way from funding. Local decisions can still be made around spending and curriculum and all of that under current law. And you all, as the legislature, get to decide what that looks like.
anything else? Okay, thanks, Beth.
Thanks.
Thank
That's
you.
really helpful. We'll come back in 5 minutes for Christine Holquist, and here's a copy of the bill that we're gonna be looking at,